the projector up too. So my idea was that we, rather than just have presentations as part of the regular CAC meeting, which may or may not be something that the community is interested in.
Right.
Because maybe just the thing that CAC is trying to learn more about. That we actually do some webinars and we actually bring some people out. So one of the questions is. Yeah, Kirsten's sick too. So she says she's down, she's got the plague. So she is sicker than you.
They thought I had pneumonia. Not good. You'll be, yeah, haven't had this didn't work. Wow.
Anyway, so I guess the question is, and I'm going to open it up to both the panel and the public.
Yeah.
About what thoughts you guys have about, one, doing webinars, and two, if so, what kind of topics. And let me just suggest one thing, and that is that one of the areas that we might do is to use webinars to help inform the public about recommendations that the CAC has made to the sheriff. So, we could have done something, and maybe we still could do something on our proposal to have attestations because of the extremism in policing. And the sheriff actually has done a good job with the attestation, but we could have a whole webinar on that. That's and so that we could have a webinar if the policy review committee wants on the canines.
Yeah, I was just.
Yeah. So, but other ideas, and if you think webinars are a good idea, both of
I
those.
think webinars are a great idea, and I also think we might want to go out to some of the communities and ask them what they'd like the webinar on. Yeah, that's, because I don't think we're always necessarily gonna come up with the topic that they want to hear about or they want to participate in, although I think those would be, I certainly think use of canines and extremism are so very important. I mean,
And when you say, go out to the community, how would you do that?
So I just remember, hearing about, when I was at the conference and since about,
Oh,
about going into some neighborhoods, going out to, I don't even know what neighborhoods it would be necessarily, but I think going out to, some, neighborhoods where there have, where there have been issues. And, going to them instead of keep expecting them to come to us. And, as last time we saw when we had that session and basically nobody came. I think Susan, you were the one who said, people said to you, nothing's ever gonna change, so why should I go to a meeting? But if we went to them, they might feel like, oh, maybe something will change, if they're coming with us to hear about I don't know all the neighborhoods. I'm just saying that I think there are plenty of people out there who would like us to come to them.
And there are also lots of groups to pull in. That are tangentially into, like NAACP or Childhood Justice or, all of there's a number of them. And, by including them and actually having them as part of the revenue, somebody from them, that.
right, I was not thinking that the CAC members
no.
would necessarily do it. What I was thinking more was that if anything, the CAC would
Partner with other.
probably be here later. And Lorraine will be here later. Okay. I was thinking that we would invite so-called experts to come.
Oh, absolutely, it wouldn't be us, but
Yeah.
I'm just saying, there might be on some given topic where you have some experts, but you also have somebody from the NAACP.
Right.
The group,
Right,
so that they're in the mix.
right, right.
Yeah.
Yeah, no, I think that's a good idea. Especially. So, yeah. I think one of the things that we can do is also, depending on what comes out of our meeting on the 24th, that might, substantive topics might come to mind that beyond the ones that we mentioned here tonight.
I also think, I mean, because this is what I wanted, some of, as a CAC member. I feel, I wish that I had had a little more training in some of the basics of, oversight and just the, like the one that we're having tonight. You know, some of the basic laws and approaches of the sheriff's department and how what am I supposed to be looking for? I didn't even know some of the basic laws, you know, that I feel like in terms of disclosure, like we're gonna hear about tonight. You know, disclosure, you know, records, and you know, stuff like that. I just think some of those basic things might be helpful for people to know about, so that when they are thinking about submitting some kind of an issue or a complaint, that they have some framework for doing that.
Right. If you guys don't mind, I'm gonna shut the doors.
Okay.
Because just with that other door open, I feel a draft.
So, anyway, I don't know if that makes-
Yeah, no, I think that's great. Just one of the questions I have is how, the ideas about how we would go about advertising and putting out the fact that we're doing these webinars and attracting them. You know, ILR has an email list. We have the website, although CAC is pretty good on the website. We'd like to bring us forward better so that we don't have to go searching for us. Focus on that. But it seems to me that that we ought to be doing things beyond that.
Well, it seems to me if we're dealing with, things that are already in the public eye, things, the K-9 stuff, and, you know, K-9 incidents have been covered in the press conference. If we can approach the, reporters in such a way, connected to stories that they've already covered, they might, let people know that this is happening.
Right.
The connection.
We could, you know, we could even do their 10-day.
Yeah,
calendar.
right, exactly, yeah.
What about, I mean, the sheriff is going out and holding community meetings,
The town hall meetings. Yeah.
town hall meetings. When did we kind of somehow tag along on that? I mean, in the sense of, they probably wouldn't hand out a flyer, an announcement about that we would be coming, you know, to do a neighborhood meeting as well, but it seems to me that we might be able to somehow, not use their advertising, but use their outreach, you know, where they're reaching out and we could, how are they doing it? Why, you know, why couldn't we do some of the same, use some of the same tools? Is that crazy?
I don't think it's crazy. I just don't know how the sheriff's office would respond to a request that we.
Well, we could just show up and announce.
Well, I think.
Robin?
Use
Oh.
their,
No, I know,
No, but that's.
John
fine.
John wants to talk.
okay, drop that idea.
Sorry to interrupt, but I was going to say, we do use the same tools already that the sheriff's office uses to promote their events. I think the biggest single difference I could point to in how those tools work is just vastly more people are signed up for the sheriff's website and Facebook and the like, and their newsletter. So they have 100,000 people on their email list. We have maybe a tenth of that. And so some of it is just that, you know, it's a larger agency with a larger staff for PR, right? And also been around longer. And they have opportunity to touch more community groups. And so there's a lot more opportunity for the sheriff's office to get people's attention, right? And, you know, 100,000 people that's a big portion of I mean, assuming they're all in Sonoma County, that's a really big portion of the county, right? So some of it is getting people interested in just, signing up to be on the website or be on Facebook. So we're using the same tools. We just have a much smaller footprint and much smaller resources compared to the sheriff's office, if that makes sense.
Hey, is it completely naive? Okay, tell me if it is completely naive to talk to somebody in the sheriff's department about our interest in being more visible out in the community and ask them, how we might tag along on some, not on their town halls, but do they have any interest? I mean, it should be a public issue if they have no interest in, in our being able to get out into the community and
So are you
create some
suggesting,
oversight.
are you suggesting something like asking them to, like, I got a newsletter from them today or yesterday, I can't remember. So something like saying, would you publicize our event in your newsletters? Is that the kind of thing you're talking about?
Well, or letting us be at one of their town halls and say something. I mean, like she said, show up. I mean, so that we're not there as a protester necessarily, but we're there as a member of a community. And that, we might be able to say something about oversight.
Yeah,
I mean, I think they're gonna like it. I don't think that they're gonna like it, but is that something that we?
It's certainly worth exploring.
certainly as part of webinars, there would be ones where it would be totally appropriate to have a sheriff's representative as part.
Sure, absolutely.
And then you would hope that they would want to do advertising.
Right, right. No, absolutely. Absolutely. Well, listen, we have now 8 minutes.
I was just gonna say something hard to ask if maybe they can, the sheriff can send something out about like. Something that we're doing, and then in exchange, we can also say, hey, when you're doing a town hall, we're happy to. Put it in our newsletter too, but it's like sharing information about community events,
Right. I mean,
not there to attract.
from my understanding of going to some of the things in, at the NAPOL conference, there were communities that were working together. I mean, the sheriff's department was not totally, opposed and wanting to bury the oversight, groups. There were efforts in some communities to support the work of the oversight committees. Commissions. And so I think it would raise a profile, raise the public profile of the sheriff's department if they did do something to kind of promote that citizens have a right to do this. And if they're not afraid of what they're doing, then they shouldn't be afraid of saying, here's the CAC and you might want to hear what they have to say. I mean, they should want to.
So we'll put that issue of going to the sheriff's town halls on the future agenda, since that's not on our current agenda.
Jim Duffy has his hand up too.
Okay, Jim?
Thank you for taking my comment. I have two suggestions for educational webinars. One would be the thin blue line flag, and you could get reps from law enforcement and representatives from communities who find it offensive and let people explain why they feel about it the way they feel. I think that it's a very controversial thing, and part of what CAC is supposed to do is to bring people together. So I think educating people on the different perspectives would be important. Another idea is that the sheriff's cooperation or non-cooperation with ICE. It's a lot of misunderstanding in the immigrant community on what's going on there. And then my last comment real quick, as for advertising the events, my experience in doing webinars is if you get co-sponsors and you do it with a bunch of groups, it really helps juice attendance. So once you pick something to do, pick a few groups that you want to work with doing it and give them a 3-month lead time so they can get their boards to approve it. And you'll probably get better attendance. Thanks for taking my comments.
Thanks for giving me. Okay, so let's move on to future agenda items.
New members.
I'm sorry,
New members for the community engagement. Recruitment of new members.
okay. I'm calling us the CEC.
Oh, okay. Okay.
We had some, I will tell you what we had from our last meeting, which was talking about better graphics. Developing contacts in the media, including like making an appointment with the executive editor of the Press Democrat and reaching out to La Prensa. Using neighborhood Facebook pages. Reaching out to the maps and using Nextdoor. I think Nextdoor. This is, so those are just ways to, you know, to get our message out, which sort of coincides with our discussion about how to promote the webinars that we want to do. And then there were a couple of things that, John, that were on your list. See there?
Sure. I thought it might be good to talk about, and I think, we hit this a little bit tonight. What other groups might you go to ask them to engage with you? Because a lot of our engagement so far has been to the, the general public. It's been on radio to everybody. It's been on the web to everybody. It's been at specific events where we show up and we talk to just the individuals that are walking by the booth, right? But I wonder if it might not be valuable to pick some particular organizations, either geographically based or interest group based, that might be folks with whom we could be working closely, kind of like the comment that Jim Duffy was making about how if you put together a webinar and you co-sponsor it with a group that's interested in the same topic, you tend to get more traction. I wonder if that might not be a bad idea for figuring out how we could proactively engage with, groups that have interests that align with the ones we're working on, as opposed to reaching out to the public in general. So more targeted, right, with existing organizations.
Are you talking about working with those, talking directly to those groups, or you're talking about having them be at a community outreach meeting that we would have with the public and they're because of the sharing, the common interests? What are you talking about?
I would start with the first one and then I'd go to the second one.
Well,
Anything else? I think we've run out of time. Almost. Well, one thing I did, report, I'm gonna report it at the CAC meeting as well, but I'll report it here, is that Lizette, John and I had a conversation about figuring out ways for ILO and CAC to collaborate on a community engagement plan. And my personal thing is that we should have an actual plan for the year that we would then execute, and would be able then to measure our success or failure at community engagement.
yeah, I think that's a good idea. I think another topic for one of the webinars would be how ILARO even works.
I sort of thought that your basics of oversight was that.
Yeah. I mean, there's like general oversight principles, and then there's like what actually happens within ILARO when something, when something gets submitted or something. I think those are two different things.
Anybody else? Okay, this meeting is adjourned? Adjourned, okay.
Hey, before people walk away, I'm getting some feedback from the public that they're confused about the Zoom links. Is this the same Zoom link for the regular meeting?
Yes.
Okay, Because I think originally they were advertised as two separate ones. So a few people have tuned in and gotten to me and are like, did the meeting already start? What's going on? So maybe Nancy, could you do a little announcement about that transition here so it's a little clearer to the public about what we're doing?
Yes, so for those of you on Zoom who have been here for the community engagement meeting, you can stay on Zoom for the CAC meeting. Do not hang up. Or if you do hang up, go back to the same Zoom.
Just check that the audio is connected to the owl, please. You just go to the little arrow where the mute is. It should be on echo.
Thank you.
John, can you say something? So we can see if the mic on the owl is working, please.
I can unmute.
Select the microphone, echo.
This is Liz Coleman. Is the mic working?
Thank you.
Thank you.
So I'm sitting in Lorena's chair, but she's still the chair.
Okay. Welcome everyone to the February 7th CAC meeting. We'll go ahead and call the meeting to order at 6:01 p.m. and we'll just go around the room and CAC members just state your name and what district you represent. Yeah, I'm Lorena Barrera, representing District 3.
Nancy Pemberton, District 5.
Lisa Camacho, Community Engagement Manager with ILR.
Good evening, everyone. I'm Darnell Bowen. I'm at large committee member.
George Valenzuela, District 1. Trevor White, District 3. David Jones, District 2.
Rogers, District 1.
Okay, and we have community members joining us in the at the table. You're also welcome if you want to sit at one of the empty chairs. Next we'll go over the commitment to civil engagement.
I'm gonna read this time, but that's it. It's gonna be the last one. I'm gonna read it from now on. Other people can either read it or we will all agree that we know what the specific engagement rules are and you're free to abide by them, because this is really boring. So all are encouraged to engage in respectful, non-disruptive communication that supports freedom of speech and values diversity of opinions. We, the members of the CAC, have adopted a list of norms referred to as our Design Team Alliance, which describes the way we want to show up and be in community while modeling collaborative behavior. We request that CAC members, staff, and the public follow the CAC's agreed upon norms, which are to be tough on the topic, not on the people. Respect all participants in the meeting, respect each other's perspective, even when we disagree, respect each other's time, stay within the meeting's time and content parameters, practice active listening, listen with an open mind to all information, including dissenting points of view, speak to others as you would like to be spoken to, allow others to speak without comment or intrusive sounds, honor freedom of speech, and call each other in.
Thank you.
Lieutenant Jones wants to introduce.
I'm sorry.
Lieutenant Jones.
Someone wants to introduce himself.
Okay, go ahead.
Hey, sorry about that. I didn't have a button to unmute. I'm sure I'm not doing this right, but I just wanted to say that I'm here, Sean Jones with the Sheriff's Office.
Thank you for being here and was that again in the post? Yeah, thank you. So next we will move on to the approval of the January 3rd, 2024 minutes. And even if you didn't attend the meeting, we're just approving the minutes, so you can still vote on the approval. So hopefully everybody had an opportunity, and sorry that I had never said that before. An opportunity to review the minutes. Does anyone have any comments or changes to the minutes? Okay, seeing none. We'll open it up to public comment. Is there any public comment for the approval of the January 3rd meeting minutes? We don't have any comments from the room. No, Did you have your hand raised?
Yeah, I noticed that, when public, when members of the public comment on an item, they're not named, so, I'm uncomfortable, failing to name the people who comment on items in the minutes.
Okay, thank you for your comment. Seeing no other comments, we'll bring it back to the CC. Is there a motion to approve the minutes?
So,
I'll second.
Okay, thank you. All in favor?
Aye.
Aye. Any abstentions? No's? Okay, thank you. The motion carries. Openings and appointments. We have an opening in District 5, and then we also have an opening in District 2 as Tom sold his house and he is no longer in the district, and he decided to step down from his position on the CAC effective this meeting or yeah, essentially. But I'm sure he really enjoys his time with us, and we thank him for his time and all that help. And I know he did a lot of tabling events with that. So if you know anyone who's interested, please encourage them to apply so we can fill our vacancies. Item 5, correspondence items. I don't think we have any correspondence items to report. Moving on to item 6, director's report. John, we'll turn it over to you.
Hi,
Hey, John.
thanks for having me. Sorry, I'm not there in person. Two things about that. One, I've got some sick kids and no one else to take care of them, so it's my turn. But then in addition to that, I feel a little bad about appearing remotely because I know the current Brown Act rules since maybe middle of last year are such that the CAC members can't do this, and that seems not right to me. But since the Brown Act allowed me to do this, I thought it was better than showing up remotely than not showing up at all. So thank you for bearing with me tonight as I appear remotely. A couple things I wanted to echo. The comments that Lorena made about Tom Rose. We're going to miss him. I did get a chance to catch up with him and thank him for his service before he left town, but he did have to move out pretty darn quick. He, was fortunate that he got an offer that required him to sell fast. So I think that that's good for him, but we'll miss having him here. I went to a lot of outreach events with him, and I really appreciated that he put so much time into that and spent a lot of time talking to the public. And I also appreciated that he signed up for a lot of committee work. He was a really active member of the CAC, and I'll miss having him around. So, that said, there is now a vacancy in District 2. So if people are interested, let us know. Supervisor Rabbit, of course, makes that appointment. And so that'll be up to him to pick someone to fill that slot. I know an item for, later in this meeting is the retreat later in February, and I'm looking forward to seeing you all there actually in person. And I know we've gotten RSVPs from the sheriff and from Supervisor Rabbit, who's now the chair of the Board of Supervisors this calendar year, that they're both going to show up, and I really appreciate them making the time. And I think it'll be a great opportunity to talk about how we want to structure the work of the CAC for the next year. I know we'll talk about that some more in this meeting, but looking forward to that. I should mention to all of you that at some point, probably before our next CAC meeting, we will need to close the Iolero's office for a little while, our physical office, because we have a construction project going to reconfigure some of the office space. One of the reasons we're doing that is to make sure we have an interview room, but also to make sure our front office entryway is more secure. So there will be a time in February. I don't have an exact date yet, but I'm pretty sure it'll be before our next CAC meeting, where we'll close the office for at least a couple of weeks, maybe as many as 3, and we'll do all of our services remotely. So for those of you looking for us, we'll still be keeping our website going, and we'll be available by telephone and email and Facebook and all the ways you normally reach us, except for stopping by in person. So apologies in advance if that inconveniences anyone, but wanted to let you know about that. Any questions for me before we go to the next agenda item?
When you say the next CAC meeting, do you mean the retreat or the next monthly meeting?
Well, for sure before the next monthly meeting, and I suspect that once we get the date for the construction nailed down, it might be shortly before the next um, retreat, before the retreat in late February. So, the retreat is going to be the last weekend in February, and then our CAC meeting is the first Wednesday in March. So it'll be probably very close in time to the retreat.
Thanks, John.
You're welcome.
Sean, we'll turn it over to you. Lieutenant Mills.
Yeah, thank you. Obviously, I'm remote as well. I'm a bit congested today, so I'm trying to keep that away from you guys. I plan on being at the retreat as well, so I'll see you guys there. And we have a community academy coming up in March to Sheriff's Office, and just I think some of your membership has been to a community academy before, but if you haven't, it's pretty insightful time to learn about the Sheriff's Office and all the things that we do. So if you're interested in that, reach out to me. I can put you in contact with the person setting it up. And that's all I got.
And can you remind us how long the academy is? How many weeks?
Yeah, it's like 4 different days in March.
Okay.
Saturdays.
Saturdays.
Yeah, and I can get those dates for you if anybody's interested.
Yeah, if you could get that for us and then send it to Lizette so she could share it with us, that would be great.
Okay,
Thank you.
sure.
Yeah.
Sean, I am interested in the town hall meetings or whatever it is that you're having. So I'd like the dates for the upcoming one that didn't you just mention one?
The community.
Community Academy.
Oh, the academy. Oh, not the academy. Oh, I thought you said that you were having community meetings. That's not what you're talking about.
Oh, yeah, the town hall meetings.
Yeah.
Yeah, those are, yeah, I don't know when the next one is. Those are going to, they're gonna be a quarterly, on a quarterly basis coming up this year. So, I can certainly keep you informed on when the next one is.
Yeah, thank you.
Sure.
The next one's in Spanish.
Better learn Spanish.
Oh, no, I'm sorry. That's the community academy.
So do people know and understand what community academy is? Because I don't know. I would be interested in hearing just a nickel version of what that is.
Yeah, can you tell us a little bit about that?
Yeah, sorry. So, we just basically have a lot of presenters, talking about different areas, of the sheriff's office and things that we do. And, really it's just a gathering for you to understand what we're all about. So for instance, I'm looking at the schedule here. On day 1, we'll have an overview of the sheriff's office. You'll talk to a representative from personnel about hiring, all that. You'll have a representative talk about training, the academy, FTO stuff. And you'll have managers and supervisors in certain units and collateral assignments that'll come and speak to the group about canines and SWAT, and you'll get to see certain equipment, as a little tour, but it's pretty insightful. And I think I can't recall if it was some ILRO staff members or members of the CAC that have been through it, but I'm pretty sure some of you have. And I urge you to apply for that if you haven't.
Yeah, you have to fill out an application on their website. They are gonna have one in Spanish, but I don't think they've got it scheduled. They probably want to see how many people are, that will be completely in Spanish. Does anybody get their newsletter?
Yeah.
The sheriff's newsletter? It just came out yesterday, I think.
Yeah, last night.
I'll send Lizette all the details.
There's a thing on the community academy in there, the latest newsletter.
They also share on Facebook, on Sonoma Sheriff page, Facebook.
Thank you, Sean.
Welcome.
Thank you.
So leave that in, I have been.
Can you forward me that newsletter?
Okay. we'll move on to item 8. Presentations, and we have receive and discuss presentation on Penal Code 832.7.
Liz, did you want to share your screen or did you want me to pull it up?
I think it's probably easier for me to do so.
That's fine.
Let's see here. Can you see the slides?
Yes.
Great. Good evening. I haven't met all of you. My name is Liz Coleman. I'm one of the deputies in County Council that works with ILARO. I was asked to give a presentation about disclosure under Penal Code Section 832.7. It's a little bit dense. It's a very tough statute to get through just reading all of the language in it. So this is a fairly dense presentation, but please feel free to ask questions. You can ask questions at the end, or if Lizette notices that somebody has a question, feel free to stop me. Sometimes I get in the zone and don't realize. And apparently it's cold season. I apologize in advance if I'm a little bit sneezy, but I will do my best to spare you from my coughing. So let's see here. So the basic topics I want to talk about: what must be disclosed under the Penal Code section, when and how must disclosure occur, and how does ILARO review fit into disclosure. So a little bit of background on this, on the lay of the land. In 2018, the Right to Know Act was passed, which broadened the public ability to obtain records about police shootings and other significant uses of force, as well as disciplinary records. Also in 2018, there was an increase in transparency in terms of recordings of critical incidents. So that's things like body camera footage and other types of recordings. And then in 2021, there were expanded categories of misconduct that were subject to disclosure under the revisions to the Penal Code section. And in terms of the history of Penal Code section 832.7, prior to these changes, it was really more about making most peace officer employment records confidential. And then as these exceptions came in by statute, it now is the home for all of the language about what types of things must affirmatively be disclosed. So as it's structured now, it states the general rule that employee records are confidential as they relate to peace officers. And then it goes through the exceptions allowing or requiring the disclosure of certain types of information. Okay. So there are a couple of different categories that appear in the Penal Code section. Some types of findings or some types of information need to be disclosed whether or not there are findings of a violation of policy or law, and others are unrelated to whether or not there's a violation. So first,
If you just hit the little line to minimize the window. That. Yeah, okay. So you want, is that what you want? Yeah. Sorry about that. We just couldn't see you.
oh, sorry. Should I?
Go ahead. You're good now.
Okay. So as it relates to records that need to be disclosed regardless of findings, those are those involving officer-involved shootings and great bodily harm. So officer-involved shootings, an agency must disclose records relating to any incident in which an officer discharges a firearm at a person. So this applies even if no one was hit. It applies even if there wasn't an investigation. And it applies whether or not there are any findings that there was a violation of policy or law. So this is a fairly broad category of disclosure. Great bodily harm or death is a similarly broad category under the Penal Code section. An agency must disclose records relating to an incident that where an officer's use of force resulted in death or great bodily injury. And the term great bodily injury is a term of art. It doesn't have to always be something that we would colloquially think of as being a great injury in order to qualify. So there's a legal concept of a serious bodily injury, which is sort of more intense form of injury. And there's case law indicating that it does not need to be that bad. So if there's ever a question, the lawyers will end up parsing what precisely the level of harm was involved as it relates to what needs to be disclosed. But when there is great bodily injury, it must be disclosed even if there was no investigation and whether or not there are any findings that an officer violated a policy or a law.
Excuse me, please, you said feel free to interrupt, question here?
That's for the CAC. We'll open it up to public comment after her presentation.
Oh.
Thank you. Sorry about that, Liz, go ahead.
So some records are only to be disclosed if there is a sustained finding. So in contrast to to great bodily harm or an officer involved shooting, these are the types of records that only need to be turned over if there has been a sustained finding that there was a violation of policy or law. So first, I want to talk a little bit about what counts as a sustained finding, and then what records then fall under those categories. So the statute defines a sustained finding, and this is in a subsequent penal code section, as a final determination by the agency, hearing officer, or other applicable investigating agency following an investigation and an opportunity for administrative appeal that the actions of the officer violated law or department policy. So it needs to be final, and there needed to have been an opportunity to have the administrative appeal before such records would be considered disclosable under the statute. And so I'm going to go through the list of types of claims that will lead to release of records where there's a sustained finding. And I just want to note, as I go through the slides on the next couple categories, I put notes on the bottom as to whose finding it has to be. So as a general matter, there aren't any categories where a finding by the law enforcement agency itself isn't sufficient, but there are some that indicate that where an oversight agency makes a finding, that is itself sufficient. So on ones that, the first category I'm going to talk about is sexual assault. And on this one, you'll note that either a law enforcement agency or an oversight agency finding is sufficient to count as sustained. So that means even if the sheriff's department investigation and thorough process doesn't find a violation, if ILARO does, there may ultimately be disclosure. So talking about specific categories of incidents, sexual assault on a sustained finding, the records will be disclosable. Sexual assault is defined broadly for the purposes of the statute. So it's it's a pretty complicated wording in the statute itself, but it breaks down into a couple of concepts. So if there is a sexual proposition or engaging in sex acts with a member of the public while an officer is on duty, that counts as sexual assault for this purpose. So you'd need to be on duty for a proposition or a sex act to count, but coercive acts or attempts, which are a threat, an offer of leniency, a use of force under color of law, those count as sexual assault whether or not an officer is on duty at the time. So because those are a higher degree of culpability when there's color of law attempts to coerce somebody, right? That's a higher category of misconduct. So those types are considered sexual assault whether or not an officer is on duty at the time. But something like a proposition or engaging in sex acts, which of course can be consensual under the right circumstances, are only considered assault for the purposes of this statute if they're engaged in while on duty. So the next category that is disclosed on a sustained finding is a dishonesty issue. So the disclosures required of records relating to an incident in which a sustained finding is made of dishonesty related to the reporting, investigation, or prosecution of a crime, or directly relating to the reporting, investigation, or misconduct of another peace officer. So it is not just a generalized conduct that involves dishonesty. It has to be directly as it relates to the investigation or prosecution itself. It has to be clearly tied to the law enforcement activity. So examples here would be perjury, false statements, falsifying evidence, or concealing evidence, those types of dishonesty. And disclosure could occur whether it was a direct law enforcement agency finding or the oversight agency making a sustained finding.
Can I have
a court finds that somebody has committed, an officer has committed perjury while testifying as a witness to the investigation, is that a finding by a law enforcement agency or no?
That's a good question. I hadn't thought of that as a specifically, oh, John has an answer off the top of his head. I would have said there were other rules that apply, but John?
Probably it would, but more importantly, if a court did that, it would already be public because that proceeding would happen in public. So the rules that Liz is describing here are rules about making public internal personnel investigations that normally would never be subject to public disclosure, if that helps.
Well, unless
Does that make sense?
Unless the court did it off the record.
But a court could not enter final judgment off the record in a way that would be a
Right.
final appealable order. So by the time you've got a final ruling, that would no longer be a consideration. And we'll talk a little bit later about the timing of requests and how they are made. So these are really all in the context of Public Records Act requests. These are ways to get information from the public agency itself, as opposed to from a court or from some other forum. And there are rules about delaying disclosure while proceedings are still ongoing. So it's certainly possible that while a court was dealing with a criminal case, there would not be the ability to obtain via Public Records Act request this type of information. But once that was final, then you'd be able to go back and likely access this information.
I have a question. I'll just talk about the, the release of records. What about in the instance when a whole record is not released, like a whole body cam footage is not released, and then another request has to go in for more? Is that considered dishonesty or concealing of evidence, or, I mean, where does that, because that certainly has happened in the past.
If there was a sustained finding that the failure to turn over footage was itself a violation of law or policy, and it resulted in a final determination, then it is possible that that act itself could itself be the basis for additional disclosure. But it would have to be that the failure to disclose would have to itself have been something that was found to be culpable dishonesty. But it's a reporting investigation, but it may be difficult to put that under the rubric of the reporting, investigation, or prosecution of a crime, right? Because if the dishonest conduct is in the context of your response to a Public Records Act request, it's not that you would probably be difficult to argue that that was related to the reporting, investigation, or prosecution of a crime. I mean, you could potentially make the argument that it was directly relating to the investigation of misconduct by another peace officer, but it is, my gut is that would not likely be a well-received reading of the statute. John, do you have a thought?
Yeah, I was just going to say, again, Robin, it's important to remember here that the rules that Liz is talking about are rules that have to do with disclosing personnel investigations into individual officers. So none of this really talks about, what's the remedy if the public disagrees with an agency's decision about which body-worn camera to release, right? That's a wholly different process with different mechanisms for resolving it. So the only issue we're talking about here is if there's an investigation into an individual officer or deputy about their personal misconduct, when does that information become public? And it doesn't really tell us about a wide variety of other circumstances where there are other things that an agency might need to make public.
Thank you.
Yep.
And John, thank you for jumping in when you have specialized information and knowledge on these. You are probably more expert on several of these topics than I am. So the next category of items that are disclosable on a sustained finding is unreasonable or excessive force. So remember, this is in contrast to when we were talking about great bodily injury previously. That's about the impact on the person, but a use of force that could be unreasonable or excessive, even if it doesn't rise to the level of causing great bodily injury. So this will cover that lesser included category as well. But this would be only on a sustained finding. So here, the rule is that disclosure is required of the records relating to a sustained finding of unreasonable excessive force, which is defined effectively to say, it's not defined terribly concisely in the statute. So I've boiled it down here. An officer is allowed to use objectively reasonable force to effect an arrest, to prevent escape, or to overcome resistance. And it's evaluated on a set of characteristics set out in the penal code elsewhere. So excessive force is force that's beyond a reasonable force or otherwise violates law or statute. So there could be a specific rule about a type of force that could then be a violation, or if it exceeds what is reasonable under the balancing test set out in the penal code. And law enforcement agencies are required to maintain use of force policies. So some aspects of that could be on the more amorphous kind in terms of like the proportionality. There could also be specific maneuvers that are allowed or disallowed. So a violation of either of those types of policy could give rise to a sustained finding of unreasonable or excessive force that then needs to be disclosed. And I just want to note there is no reference in the statute to an oversight agency finding as to being sufficient for disclosure. So it is unlikely that a finding from ILARO that was at odds with a finding from the sheriff's investigation, ILARO finding a unreasonable or excessive force would not necessarily be sufficient to then disclose those records.
Quick question, sorry. Do you happen to know where in the penal code the further definitions are for objectively reasonable force?
I do not have them in front of me, and I'm happy to, let's see here, my email follows the convention for the county. So if you have any specific questions, feel free to send me an email and I can respond separately.
I have a quick question on the disclosure by the sheriff's department. Do they have a webpage where they disclose the officer involved shootings and the findings, or how will the public know?
Yes, they do. And we, that's on a later slide. I have a link to where the sheriff's office maintains a list of the items that it finds disclosable. And that's going to cut through a lot of the process on a lot of these. So just because something can be obtained by a Public Records Act request, you probably don't need to as to a lot of items on here because the sheriff maintains a list. There's probably, there will be timing differentials since it may not go up on the website, because the statutory timeframes may be tighter than that which the sheriff is internally using for something it's doing of its own volition. The timing may be different, but most of this can be obtained from the sheriff directly.
And does that footage, can it be altered, or must it be free from alteration?
Can what be altered? I'm sorry.
Video footage of a bodily shooter, like body worn camera imagery. Because in the Chavez case, the sheriff had the video like edited for a while. So I'm trying to understand, like, they can release it, but does it have to be free from alteration?
John, is your hand up on this one, or is it just up from last time?
Yeah, I was going to say that as to the question that Darnell is asking, this is kind of beyond the scope of the presentation here, but in addition to I don't mean to be difficult or not answer your question, but in addition to the rules that Liz is talking about tonight, there are abundant provisions in the California Penal Code and some other places that make a lot of the interactions that law enforcement have with people private. So, for example, when law enforcement responds to an injury that someone has, even those that are caused by law enforcement using force, they'll have conversations about how to provide medical treatment, right? And we have to, by state law, we meaning the county and other agencies, have to blur out the medical information or delete that out of the audio track when we release the body-worn camera footage. If the incident involves victims of domestic violence or child abuse, those victims' identities have to be preserved. And then that means we end up blurring out their faces or their voices. There are a host of other protections like these that all apply. And so in addition to that, there's some, limited ability in the penal code for an agency to blur out some of the the body worn camera footage they have. And that, gets complicated, but, usually that has to do with blurring out things like, or deleting out of the audio track, material that's derived from people's criminal history. So if a deputy is calling in to dispatch and trying to get information on an arrest warrant or someone's prior conviction history, there are federal laws that don't allow them to disclose that material to the public, so they have to blur that out too. The list goes on and on and on and on. So release of body worn camera footage ends up being incredibly complicated because you really have to have basically a lawyer review all of it and see if any of these numerous exceptions might apply to any part of it. It's frustrating for the public because they don't always know why the body worn camera footage might be blurred or muted at some point. But on the other hand, when people go through each of these other individual reasons for withholding that information, usually there's pretty broad consensus behind all these other protections, like the protections for, juveniles, for example. So all that's to say there isn't an easy answer, but yeah, all of these records do end up still having some kinds of, redactions or mutings or blurrings for all of these other reasons I just mentioned. Sorry, that's not an easier answer. It's a really hard field.
I also want to say something that I think was at least suggested by Darnell's question, which is, if the sheriff's office has a policy of using its website to publish that which the sheriff's office deems relevant after an event, what the sheriff's office puts up on that site is not necessarily complete in any way, because they're not doing it subject to an obligation. They're doing it to get out in front of a public information situation. Independent of that is the rights of the public. So in other words, Darnell, my read is that what certainly the door is open for is the sheriff's department makes its determination. Here's what we want to put into the world about this new event. And they do that in whatever way they think is useful / advantageous / message control / disclosing all that we're willing to disclose at this time kind of thing, right? So that's one thing. That they're not doing that because the law is demanding it. They're doing it for other reasons. Now there's a separate avenue where you can use 832.7 to say, here's my request for all that you hold on this matter, right? That's a different animal, and it's likely to end up with the disclosure of an entirely different additional set of information, because it's subject to a legal requirement as opposed to a SO determination. Here's what we want to tell the world about the event that took place.
So you could have two sets of video, basically, or multiple.
Yep, that's right. And it's also, if you don't mind me jumping in, it's also the case that now that these state laws are in place, I think as Casey was alluding to, members of the public can go to law enforcement agencies and ask for the materials described here if they think that what's already available in the public is less than what the statute provides access to, right? So if someone thinks that either ILARA or the sheriff's office hasn't provided everything that they should or could under these statutes, then one can make a Public Records Act request and demand that either one of us do it.
Thank you.
Go ahead, Lieutenant Jones.
Yeah, thank you. I just wanted to mention, I think it's important to state that sometimes those videos that are released by the sheriff are meant to be a community briefing, kind of an overview of the entire incident, rather than just a full unredacted version of a body-worn camera. Those aren't meant to substitute for the requirements that you're hearing about tonight. Eventually all that material makes its way to the website. Those community briefing videos that you see that are edited with map overlay and all that in the 911 dispatch tape, that's meant to just be more of a briefing video over the overview of the incident.
Thank you.
Thank you.
George, did your question get answered?
Yeah. Gotcha.
Shall I keep going?
Yeah.
Okay, so the next category is someone's mic is on and I am there, but it's not. Sorry, I was getting an echo of my own voice, which was wildly distracting. Okay, the next category is you disclose unsustained findings of a failure to intervene. So disclosure is required where there is a law enforcement agency finding that an officer failed to intervene against another officer using force that is clearly unreasonable or excessive. So the modifier here of clearly unreasonable or excessive is important. Force can be unreasonable and or excessive under the prior definition, but it needs to be clear to the bystanding officer in order for that to be the type of situation that would lead to disclosure. So it is not like the prior slide. There's no clear definition under this penal code section specifically, but elsewhere in state law, there are requirements that use of force policies contain a requirement that an officer intercede when present and observing another officer using force that's clearly beyond that which is necessary as determined by an objectively reasonable officer standard. So the penal code itself doesn't talk in this section, doesn't talk about what's clearly unreasonable, but it's required that policy documents explain what counts as unreasonable to the officers. So there should be an objectively, there should be an adopted test that would be applied in order for the law enforcement agency to make a finding. And again, there's no reference to oversight agency findings here. If you're looking for records on a basis of a failure to intervene, it has to be solely on the basis that the law enforcement agency itself made a sustained finding. The next category is a sustained finding of prejudice or discrimination. Oh,
Sorry.
Mhm.
So is the disclosure from another officer, required like at the time that they do all of the reporting, or until it's determined that the incident was, or like that the officer failed to intervene?
Yeah, so-
In a force that's unreasonable? Is it
This is-
until the determination that the action was unreasonable, or everything gets handed over by all officers at the scene?
So this is not about a disclosure of a failure to intervene. It's that you have to disclose documents about a failure to intervene in the moment. So this is defined by whether the officer, while they're observing a different officer using force, should have jumped in the moment, not about whether they should be later disclosing records. So it's based on, there would ultimately be a determination. You would have to determine that the use of force, the underlying use of force was unreasonable to then make the finding that that not intervening was itself a failure of policy. So you would probably have to look at that in hindsight, but it's not about your later activity in whether you disclose or not. It's whether or not you did what you could to stop what should have been clearly to you an excessive use of force. So when I talk about disclosure on the top of the slide, that's just about like turning over the records when the public asks for them later. This concept itself about what is disclosable isn't about whether the officer themselves were making proper disclosures.
Okay, thank you.
But again, disclosure could be an issue, right? If it rose to the level of obstructing evidence, which is a different basis for a misconduct finding that could lead to records being disclosed. It's just not under this concept. So the next category of documents that need to be disclosed where there's a sustained finding is where there is a finding of prejudice or discrimination. As long as this definition here is, I cut it down from what was in the statute. It's pretty long, but it is what you would expect it to be. If an officer engages in conduct such as verbal statements, writings, posts online, records, gestures, anything like that involving prejudice or discrimination against a person based on a wide variety protected classifications. So these are race, religion, color, national origin, ancestry, disability, medical condition, sex, gender, marital status, a whole lot of different things. Any one of these articulated bases, that if there's a finding that they undertook activity that constitutes a discriminatory act, the records will be disclosable. And those are agency findings or oversight agency findings of discrimination. The next would be disclose on sustained findings of unlawful arrest or search. So where there's been a sustained finding by the law enforcement agency or oversight agency that a peace officer made an unlawful arrest or conducted an unlawful search, those records will ultimately be disclosable. Just a note here, this specifically does not include custodial officers. When you look at the statute, almost all of the other categories talk about either custodial or law enforcement officers in a manner that make it clear it includes custodial officers. They are left out of this. So if the unlawful search is as to someone who's already, that's an inmate in the jail, this would not be the basis for disclosure. Okay, that was pretty dense. So now we've got the list of every type of incident that would then lead to disclosure of documentation. So now, what does that mean? The next part of this is what must be disclosed, how are they released or requested, and when must they be disclosed? So the list of disclosable records is very long. This gets to the question about what needs to be put out versus what might be voluntarily released. You can take a minute to look at this pretty impressive laundry list, but all investigative reports, photographic, audio, and video evidence, transcripts and recordings, autopsy reports, materials compiled and presented for review to anyone who determines whether or not the actions were consistent with law or policy will need to be disclosed. So all of the first line evidence that exists of the incident should be disclosable. And then if there are secondary materials that are prepared in order to present them to the deciding entity, those will also be disclosable. Let's see here. Oops. And then the records related to what discipline to impose or corrective actions to take are also included therein. So the next slide deals with how you request records. As I've talked about a little bit, all of the records that can be disclosed under the Penal Code section, you can make a Public Records Act request for. There is no specific required form for a Public Records Act request. If you make a request in writing to a public agency that has disclosable records, it is their duty to work with you to be responsive. And there are generally applicable timelines. We'll talk more about that. But there is quite a lot of disclosable information on the sheriff's website, and I put the site here. And SB 1421 is one of those statutes that increased the list of types of material that needed to be released. And so they're maintaining documents that must be disclosed by law on their website for ease of access.
Can I interrupt here? You just say that you should write that down or keep track of it, because we can't search on the sheriff's website for SB 1421. And that's something that for that to come up. And it's not on any their drop down menus. So keep the website.
Where is it?
It's right there. This one.
The last line of the slide.
It's in your agenda.
It's in the
Okay.
agenda packet, but you wanna keep that. I bookmarked that because.
So if it's not searchable, how is the public supposed to find that particular sub web page?
I was able to find it via Google. It may not be accessible from a drop-down menu that specifically directs you there, but it is not a hidden URL, and it's certainly if Lieutenant Jones wants to.
But there's not a search function on the sheriff's own website. You can put it through Google, yes.
And then not only that, but most members of the public aren't familiar, don't know what SB 1421 is. So how would they even know how to find it?
Go ahead, Sean.
Yeah, sorry, it is on a drop down. It's, if you go to contact us and reports and property requests, where you would do a Public Records Act request on our website, there's a link. If you follow that hyperlink, it'll take you to it.
And just for the committee's information, when I Googled it, I Googled Sonoma County Sheriff Public Records Act request without putting in SB 14. I have it covered here, 1421, and I was able to find it.
So I don't know if Sean or Liz is in a position to answer this question, but I would be interested in knowing how is it determined in the universe of material that is available to a member of the public who makes a PRA request, right? So let's say there's 100 cases or 100 different items in which there are rights under 832.7 to disclosure. Is all of that material from all of those 100 items on this page? Or does this page only get populated in kind of an ad hoc way? Or when a specific request for one of those items is made and disclosure is made, then does that material show up on this, whereas the other 99 don't? Is there an identifiable and describable process as to what percentage of those 100 matters end up on this website?
I do not know the process for how the sheriff determines what goes up on the website. I think there is one, and I don't know if Lieutenant Jones can speak to how that works, or if that would need to be a question we take offline.
Yeah, so like Director Alden said earlier, there's a lot of redaction that needs to go into these cases before they can just be put on the website. So, and that takes a lot of time and effort from our staff. So they get updated. It gets updated when the cases get finished, or sometimes they are partly finished, and you can see that on some of them. If you, I don't know if they say it right now, but sometimes it'll say partial file, something like that. All these links will take you to a Dropbox. If it's subject to public disclosure, it'll be on the website. Everything that we have that's subject to public disclosure related to that case. So if there's 100 items, all 100 items will be on there. You know, the sheriff's policy here is to list everything on the website. I don't believe that 832.7 says that you just have to put it all out there. I think it's subject to public disclosure upon request. But the sheriff decided to just put everything out there. Anybody can look at it anytime they want, and you don't have to send a PRA.
Okay. Are there just out of interest, say on that website, are there investigative and other materials associated with sustained findings of wrongdoing by sheriff's office personnel?
Yeah, if that's subject to public disclosure, under those certain circumstances, if there's a sustained finding, that's on our website.
Okay.
I urge you to peruse through it. You'll see it all on there.
Okay, thanks.
You're welcome.
And Lieutenant Jones is correct that the statute doesn't affirmatively require that all aspects of information that might be disclosable be affirmatively put on a website in advance without a request. So there certainly could be some discretion going into the determination of what gets put on the website. I would encourage you to go to the website and see what sorts of information you can find, just to sort of see what the extent of what is put out there. But it is the case that the sheriff could put certain information on the website without putting absolutely everything, without violating the law. Their obligation is, when requested, that the information that is disclosable be shared. So, you know, there's, you know, potentially some room for decision making and an interpretation in the middle. And I say that with no knowledge of how they, and that is no statement as to how thorough the sheriff is in putting everything on the website, simply to state that it is not their affirmative legal obligation to put absolutely everything on the website for every case without any request.
Well, and even with the request, there's no obligation, is there, that they put anything on a website?
That's
The
correct.
obligation is to respond to the requester and any subsequent requesters that follow.
Yes,
Right?
that is how the statute says it. Okay. Are there any more questions on the requesting of records? So the next concept is the timeline for disclosure. The basic rule is that records that are subject to disclosure shall be provided at the earliest possible time and no later than 45 days from the date of a request for the disclosure. The way the Public Records Act request works generally is that a request should be responded to within 10 days, and agencies can request additional time if documents are either voluminous or being held in more than one location. And there is no, hard time frame on general Public Records Act requests in terms of when you have to turn everything over. So this is a more restrictive term and giving a firm statement that the earliest possible and no later than 45 days, unless there is an exception. So there are exceptions, and this goes sort of to one of the questions that came up earlier about, what if there are court proceedings? If there's an active criminal investigation going on, the records can be withheld until the sooner of 60 days or a decision made to file charges. There can be further delay if the disclosure could reasonably be expected to interfere with criminal enforcement proceedings against the officer, or could be reasonably seen to interfere with proceedings against someone else. So let's see here. If there are charges filed against the officer, then the disclosure can be delayed through the verdict in order to preserve the criminal process. And withholding of there can be a withholding of records during an administrative investigation, but it should not exceed 180 days. And I just threw this slide in here because it's a concept that comes up, related to, but not directly under the penal code section, which is the disclosure rules regarding critical incidents. So this deals with a lot of the body cam footage questions. The Government Code Section 7923.625 is part of the Public Records Act specifically. And this section provides for the release of video and audio recordings of officer-involved shootings and use of force incidents in a manner that tracks onto the penal code section. So the penal code section is intended to protect law enforcement personnel records, subject to all of the exceptions we've been talking about. The government code is putting out an affirmative requirement to release this type of material without making reference to whether it exists in a peace officer's personnel file. So there may be categories that aren't in a personnel file, particularly if there's not an investigative incident coming down, but that, are retained by an entity and need to be released. And again, similar to the penal code section limitations, the section 7923.625 also allows an agency to withhold these types of recording of critical incidents if there's an active investigation. And John had some really helpful examples here, but these are subject to significant redactions for privacy reasons. So those are, members of the public, medical information, data that can't be shared, all sorts of other things that the attorneys who work closely with the sheriff's office could probably list off a lot faster than I can, who I suspect look through all of the footage before it gets released. So then the last thing I wanted to talk about is, so how does IOLARO fit into this? I know there had been some questions about when does IOLARO get access to documents? How does that relate to public disclosure? And how does that relate to your committee? So disclosure to the IOLARO director and to his auditors, who are all attorneys that are subject to the same rules that he is per the Sonoma County Code and the government code section that makes them an inspector general type organization. as well as an operational agreement in place between the sheriff's office and ILRO for the transmission of information. So when ILRO staff obtains information, that itself is not considered to be made public. That is still an internal use that is subject to significant limitations under both state and county applicable law, as well as the agreements between the two departments. So it is very often going to be the case that ILRO has access to information before it could be released to the public, and also before it could be released to the CAC. So, it will be the case with some regularity that John's folks have access to information that the public can't see yet. Let's see here. So, and that, just put that another way, the 832.7 rules don't apply to the internal operations of ILRO. Their files do end up being considered to be treated like internal personnel files. And then, and just, to put a bit of a finer point on it, the ILRO director and auditors cannot disclose otherwise undisclosable information to the CAC in the same way that it can't release it to the public, even if they maintain separate copies. So if there's something that's in a peace officer record that the sheriff keeps, ILRO has a copy of that document and that it's using in order to do its review. The mere fact that ILRO is the one with possession does not take it out of the realm of the protections of the penal code. So everything that they have is going to be subject to the same protections that the sheriff's office does. Okay, questions. We did a lot of questions while we were going, but if anyone has any more questions, and I just want to put up front that I will be unable to answer questions that are about the application of the law specifically to any particular examples, because at that point, I'm not talking in generalities, I'm giving legal advice, and that's not the sort of thing I can do on camera in a public session. So if you have questions about a specific document or situation that you want to talk about, please feel free to reach out to me. Probably copy John and we can talk about them. And that limitation is also going to go to the public. I will not be able to answer questions about whether a certain document is or should be disclosed.
I was a little confused about your last slide and what it actually covered. So I assume those are the letters of agreement that are code section 2392. Or is that the ordinance?
You trailed off at the end there. I didn't. Could you repeat the question?
All right. So would you? So if ILRO is given information that would be disclosable under 832.7 if it were given to the sheriff, is the ILRO still cannot disclose it? Is that?
Oh, I see. If it's something that could be disclosed by the sheriff's department, it could also legally be disclosed by ILRO. So when disclosure is made to ILRO by the sheriff's department, that itself does not constitute a public disclosure. And so the fact of that transmission doesn't make it something the public can access. But if ILRO has a copy of something that can be disclosed and the sheriff also has it, that doesn't prevent ILRO from sharing it. Although as a practical matter, if ILRO has something that the sheriff doesn't, that is likely disclosable, there will very likely be a conversation about, is this disclosable, who has a copy of it, and who is the appropriate party to respond to the Public Records Act request.
Thank you.
We'll open the public question here.
We'll go through the CAC members first. Does anyone have any other questions? CAC members?
Yeah, I have a hypothetical. So a member of the public files a PRA and they get a response from the sheriff and says it's not disclosable, the item's not disclosable, but the member of the public feels that it is. Do they have an appeal right, or what's the remedy? Do they go to the county council, do they go to the DA? Or do they have to file a private action? I mean, what happens if the member of the public feels that the response from the sheriff is inappropriate and they're not disclosing something that they should be? Does that make sense?
So a failure to disclose in response to a Public Records Act request is subject to immediate right of action in the Superior Court. There's no requirement that you exhaust any sort of administrative remedies. They don't need to file a claim with the county. They can go straight to Superior Court and say, you didn't give this information. And there's no obligation to meet and confer or work with you. It's frankly something we all we all take very seriously to respond as clearly as possibly to Public Records Act requests because of the enforcement mechanism being, go straight to court.
All right, thank
Of
you.
course, if they do bring it.
So what Liz said is obviously that's the legal remedy, right? If a citizen is unhappy with a response that they get pursuant to one of these requests, I mean, they can pursue multiple avenues, of course. I'm not saying anything we don't know immediately. I mean, right, you can pick up the phone and call the sheriff and say, what the hell's going on in your office? If that's, something that the citizen wants to do. But the only legal relief, I think, is ultimately your point. The only legal relief is through action in the Superior Court.
Yeah.
Right?
That's right.
Are we talking about? What kind of filing or action are you referring to?
You would probably be filing a petition for mandamus, which is to get an order from the court that forces an action on the part of the defending party. So you go to the court and say, I filed this Public Records Act request. They didn't comply with it. Please force the county to turn over the records. And there are attorney's fees provisions associated with that. So if you succeed in compelling the county to turn over a record that it did not on its own turn over, you should be able to be made whole for your costs associated with doing so.
I have a question regarding, so you said that the sheriff isn't required to release or disclose the records on their website, right?
But this statute does not require the website to contain any specific information. It may be the case that elsewhere there are requirements that affirmatively require that sort of public listing, but it is not within the statute and it's not something that I'm personally aware of.
So what we're seeing on the website for the sheriff's department right now is being put on there through other statutes that require them to publicize that information?
Well, 1421 is what states that you need to, John wants to jump in. I will let John do so. He probably knows better than I do.
I was just gonna say, one thing the sheriff's office deserves some credit for is they're proactively taking the material that these statutes describe as presumptively available to the public upon request and just putting them out there without a request, which they can do. They don't have to do, but it makes their operations considerably more transparent to the public than is necessarily required. They're certainly only putting things on there that are lawful to put up. I think they're very careful about, and as they should be, about making sure that the material that goes up on the website is the kind of material that's allowed by law to be disseminated. But they are on their own choosing to make it more broadly available than it would be otherwise under the law. And that's a real positive. I mean, I have for some time recommended to law enforcement agencies that they do exactly that. And some of them do and some of them don't. So I think the sheriff's office deserves some credit for having been proactive about putting that material forward.
Okay, and then for sheriff's offices that don't take that proactive approach, if they have an oversight department like Iolero and Iolero receives records, at what point does Iolero know that that information can be disclosed to the public and possibly share it themselves if the sheriff's department doesn't disclose the documents on their website? Like, because once everything is able to be made available to the public, Iolero can also have like a designated area where that information is available for the public to see if, let's say, the sheriff didn't have a website. Is that a possibility?
I'm not 100% sure I followed the question, but what I can say is that Iolero currently does the same thing the sheriff's office does. We try to make the records that these statutes require be available to the public proactively on our website. And we have a section of our website that has all that material, and we include in there links over to the sheriff's office material about the same cases. So you can link over to to that material from our website if you want to see it. We do not have the resources to audit whether the sheriff's office is making all the material public that they could possibly make public. That's just too vast of a job. I don't know how on a practical level we'd actually do that. But at least on the cases that we audit, we're putting stuff out into the public. We're doing that parallel to the sheriff's office, and they seem to be doing, I think, a pretty effective job of putting out to the public the materials that they could, and I think they should get some credit for that.
Okay, so, but I guess just to add to that, so if Iolera received something, but it follows the internal use only part that was explained, and then the 45 days pass, or I guess not more than 180 days, like at what point do you know that you can share the information with the public if the sheriff hasn't finished sharing it? I don't know if that's making any sense.
Yeah,
I think
I'm sorry, I didn't follow.
I think I understand the question. I think the question
Okay.
is, if I can rephrase it so that if the sheriff is not affirmatively disclosing or is refusing to disclose on a Public Records Act request, can a law enforcement oversight agency such as Iolero, not necessarily Sonoma County's Iolero, itself disclose? Like when and how do you get to do that if the sheriff is saying, no, we can't, but the time limits have actually passed? Is that the question?
Correct.
Okay. So it could be the case that the sheriff's office and Iolero have differing opinions as to whether something is disclosable, and that is something that will likely be hopefully hashed out in a collaborative fashion before hopefully one response on behalf of whatever county is at issue makes their response. But the law enforcement agencies are not bound by the failure of the sheriff's department to disclose something that is objectively disclosable. So it might be a little tricky to figure out when that is, though, if you're not the sheriff's department making that decision, because I don't, sitting on the outside, I may not know precisely where they are in the process, exactly how many days it has been since this record was created, et cetera. So assuming perfect knowledge, it may be the case that an oversight agency could release something that the sheriff's office was refusing to release, and have that be lawful and appropriate. But as a practical matter, it would be fairly tricky in a lot of circumstances for the oversight agency to confidently make that finding without a conversation with the sheriff.
Thank you. That answers my question. Okay, seeing there are no other questions from CAC members, we'll open it up to public comment. If you have questions, and Liz already stated these that she can't answer, but put all of your comments into your 3-minute public comment time that you are allotted. And make sure that your comments are related to the presentation on this. And so we can start with you if you'd like.
Sure, I wasn't really prepared for 3 minutes. I have way more material and questions than that. So just in general, who's responsible? I'm concerned about the complaint I filed against the sheriff's department. I was shot in the eye at close range with a laser guided at tear gas round. I was shot 3 times with rubber bullets, all 3 nearly hit my testicles. And I was pinned down with an officer on each arm and leg and somebody standing on my neck while the canine cop ordered the dog to release my arm and attack and release and re-attack my side 5 different times. I have not received any follow-up or notice about my complaint I made. And this happened December 5th. This happened in 2020. I filed a complaint while I was in jail in 2021. I haven't received any response. I'd like to know what I need to do to follow up on this. I believe those are criminal officers. Those officers are criminals without a doubt, and they need to be brought to justice. I'd like to know what I need to do to pursue this matter. Find out the results of that investigation.
Thank you for your comment. Any other comments from? Go ahead.
Yeah.
Wait, we're gonna start the 3-minute timer.
I want to say that people shouldn't be shy about making public records requests because it's a useful tool, especially if it relates to something you're involved in or witness that you have concerns about. Don't be shy about making public PRA requests. I made one myself to the San Rosa Police Department, and all I got back was, there are no disclosable records, so that was, so far, that's the end of it. Anyway, I was trying to get to the bottom of how 3 police officers got dispatched to the San Rosa City Hall for an alleged incident. I was trying to get some information about, exactly what was the motivating call and, the dispatch and, the reason for the dispatch, who called me, whatever. The result of 3 police officers going out to San Rosa City Hall on a certain day. And I just got a response that there was no disclosable records relative to that. So, it's quite disappointing. When public resources are being expended, and in your opinion, foolishly, you've got to have some sort of explanation. So don't be shy about making a request if you, have something you're concerned about.
Thank you. Give us 1 second while we go ahead. You can go ahead with your comment.
Yes, so in tracking the ILO for some time, previously, I understood that the sheriff's department, so in honing in on your question, was that the sheriff department had more than a year in order to actually review certain cases, and that ILO was not presented with the information until the conclusion of the sheriff's actions. And then there'd be maybe an investigation, discussion of an agreement or disagreement about the conclusion. And then whether or not it was released would be determined at some later date. And that's what I would like some clarification on, is sometimes those are 2 years and more, as this gentleman mentioned. So I was just trying to get some clarity on the specificity of something that the sheriff may not have concluded their investigation, or what are the timeframes of that for the sheriff to conclude their investigation and offer the information to Island?
Thank you. Any other comments from?
Yes. I'm looking forward to the town hall. I really have a problem that we can't ask questions, and I want to continue to bring it forward, that we used to be able to ask questions.
Is this related to the presentation?
Yes.
Because if not, we'll come back to.
So sorry, my apologies. Regarding this presentation, I would really want to thank John Alden at the very beginning for clarifying what we were doing, because I was looking at these slides trying to understand what the presentation was even about, and it's in very, very impenetrable jargon. And thank you very much, because you did a great job presenting it. However, for me, it took quite a while, and I'm pretty smart, I read a lot. So for John to say, this is what we're doing, we're talking about, getting access to records, to just clarify it really easily and really simply was super helpful, and I would really like that in the future. Just because not all of us can read all the notes before we come, not all of us are prepared, not all of us are educated in this kind of language. So just making it very simple, this is what we're going to talk about, is really helpful. And I would like to thank all the people that asked questions, because your questions really helped me to understand what we were talking about.
Thank you. And we don't have any hands raised from anyone online, so we'll close public comment and bring it back to the CEC. So Liz, for your public comment, I think you can follow up with ILARO staff, and that's what ILARO is good for, to look into your case. I don't think that's something that Liz can address at this time, but can wait until after the meeting, we can share that information with you, and that
I
could be looked
can't
into.
quite get to it, but basically there was hundreds of videos.
Yeah,
I
no, we
only
understand,
saw
we'll
30
follow up
minutes.
after.
And I never.
Yeah, public comment time is closed. And then, Liz, if you could just, maybe on the comment of at what point does, the sheriff have to have like a concluded investigation? One of those comments, if you could just address that.
Absolutely. So I backed up to this slide talking about the timeline for disclosure. I think my share screen is still on.
Yes.
So the statute indicates that disclosure of records can be withheld during administrative investigation, but of not more than 180 days. So if an administrative investigation goes past 180 days, it may be the case that documents will be disclosable, notwithstanding the fact that the investigation is not over. There's a big caveat on this, though, that several categories of documentation are only disclosable upon a sustained finding by the agency that the certain type of misconduct has actually occurred. So if, for example, there's a sexual assault allegation, if the work has not been completed yet to get to the point of a sustained finding, then you don't have a disclosable record as to that type of claim. So there are certain categories where the status of the finding don't matter at all. And those were the first couple we went through, which are the great bodily injury or the discharge of a firearm. Those are very likely to be the only two categories that are going to be disclosed while an administrative process is still going on, because you won't be able to meet the other threshold requirements of having a sustained finding. That said, it is technically possible that IALERO, which can make sustained findings on some of these categories, could make a finding sufficient to support disclosure prior to the termination of the sheriff's investigation in the first instance, if they take longer than 180 days and it's one of those specific categories. But there's a whole lot of if-thens to get there. So the general rule is 180 days, but there's a pretty big asterisk at the end of that.
Liz, can I just ask you, because that's portion of the statute that talks about the timeline also says that there's an 18-month limitation regardless. That after 18 months, the records must be disclosed. Even if the investigation is, it says, oh, hold on. But they can withhold for 180 days, they can withhold for additional 180 days, but after 18 months, that doesn't apply anymore.
It would still be the case that if it's a record that is only disclosable upon a sustained finding, that definitional requirement would still apply. So it may be the case that if you go far enough out, the time limitations that are baked into the protection, the exceptions there won't help you anymore. But as a practical matter, the sheriff's department, having finished their investigation, is going to be a substantive requirement for a lot of these categories to be disclosed anyway. So that's kind of the distinction I'm drawing there.
No, but I want to thank you for your great presentation, and Sean, thank you for showing me where to find the SB 1421 on your drop-down menu.
Well, thank you for your attention. I appreciate your attention on this rather dense topic, and I know I talked for a very long time, so.
Thank you, Liz.
Thank you. Hopefully Tom watches the recording later because he was really interested in this topic and he's no longer here. Thanks so much, Liz. Okay, so that concludes our presentations. Now we will move on to our business items. And we have one overview of the 2023 CAC retreat and preview and discussion of the 2024 CAC retreat scheduled for Saturday, February 24, 2024 in Windsor. So in the agenda packet that was published online, we have a proposed agenda. We forgot to put a watermark that says draft. And the purpose of this item today is for us to all kind of go over some things that we plan on or think that we should discuss at the retreat. And then we also had background information, which include an example of the agenda from last year. And the work plan that came about after our retreat that was approved by the CAC. So we provided a very simple agenda, and I had some ideas and comments, but I wanted to open it up to you all to see if you had any ideas on how we should have our retreat, which I think we should call a strategic planning workshop, because I feel like I told Nancy, when I think of retreats, I think of
Yeah,
it as like something fun, like. And I feel like what we're doing is planning out the year on what we're gonna be working on, and so I kind of feel like we should change the name, but we don't have to. And this is our second annual retreat. I did see that the information that went out today said that we're having our first annual retreat. It's our second, just in case other people didn't know. So yeah.
I just wanted to make one comment in terms of setting priorities for 2024. It seems to me that we haven't completed the work that we agreed to do in 2023. So I want us, when we get to the retreat, I want us to consider how much we can actually get done and not take on a whole lot of new stuff if we haven't been able to finish our old stuff. So that's just.
And to add to that, that was one of the reasons that we asked for a written report from all of the ad hoc, so that we can get an idea of the work that everyone wants to continue doing, and like how long that would take, so that when we're going over the plan for the year, we can keep certain things in mind. I don't know if, I know at my job, we recently had a strategic planning session with our council, and we didn't put public comment on agenda items on there. We just listed public comment at the top. And I was kind of thinking of proposing that we don't start the meeting with a public comment, that instead we've followed through with the agenda, but have opportunities for the public to comment at different times, like for Chair Rabbit's presentation, if they just have questions, or, and especially when we get to the part about the workshop, and not limit it to 3 minutes, because I think a workshop is more interactive, and I feel like we did that a little bit last year. But I do remember at the beginning of the retreat last year, we did do like a 3-minute public comment from a whole bunch of people that were there. And I feel like we should take that out and focus on the items on the agenda, but allow the public to comment on all of the items without having to time them 3 minutes each time. John? Sorry, and I just thought of this while I was in the parking lot before the meeting.
I think that's great stuff. And, you know, I'm glad to hear you all talking about how you want to structure your time at the strategic planning workshop, I think you called it, right? I wanted to add one other thing that has occurred to me since the last one last year, which is that I had not thought about checking in with people about who was going to be, which CAC members were going to be around for the whole calendar year. I think I just walked in assuming that all the CAC members were going to be around for the whole calendar year. And as it turned out, we happened to have a lot of people's terms that were expiring just a few months after that last retreat. And so we ended up having fewer people on board to be able to do the work that we had identified. So, you know, this year, I've been trying to get around everybody on the CAC enough to figure out, you know, everybody's plans. And for that reason, we're able to identify that we figured Tom was probably not going to be here for much longer. And sure enough, he moved away just a couple weeks ago. But that said, I just want to be clear that our understanding is that all of you are going to be here for the whole calendar year. And so if for some reason there's some CAC members that, know for sure you're not gonna be able to do that, I don't want to put anybody on the spot. I don't think we have anyone in that situation here, but it probably would be a help to let us all know, because then we'd know we have fewer hands on deck, right? And I mention that only because last year it turned out to be, we had 4 or 5 people who were all leaving pretty quickly. And they all had good reasons, no critique of any of them, but in retrospect, I wish we had assessed that. So just a thought. I hope you're all here through the end of the year, because I like having you here. So please stay. All right.
About the public comment, I'm just curious, when people make public comment in these meetings, it has to be in reference to something that's just been going on. So if any of the public have comment to make that are not specific to the agenda items, would they be able to make a public comment, apart from the specific agenda items?
Because it's a special meeting, my understanding is that it has to be related to the items on the agenda. So if they have ideas on what we should work on in 2024, it's not specific to anything listed, but they can propose that. But if they have, like, for example, the public comment that was provided earlier about, I'm gonna use you as an example, about your incident with the sheriff's office, that would be unrelated to anything that we can do. And at special meetings, my understanding is that public comment is just related to the agenda. Sometimes you could even limit it to one item on there and not have general open time. And so we would just not have general open time. We would my thought was to let the public chime in on each item as you go and like raise your hands. I mean, let's say Susan wants to comment and then she provides a comment and then later something else comes up, give that opportunity again, not do the whole 3-minute timer, but also Nancy and I would like monitor our time to make sure that we're staying on track and going through the agenda to make sure that we accomplish everything that we're trying to accomplish. That was my thought.
Well, one agenda item is discussion of 2024 CAC priorities, right? So that is a big tent, so to speak, and that's good. I mean, that's what we want to have, is a large concept. So I think that's going to permit a lot of discussion. It may not permit about a specific event, et cetera, but what are we gonna do going forward? What are the concerns about our work, about Islero, about the sheriff's department, et cetera? That seems all under that tent, right?
Yeah, and I feel like that's what our focus is. We don't want, even if the public has a lot to say to the sheriff, we don't want the sheriff stealing our time when we're supposed to be working on, our priorities for the year as a council ourselves. So I feel like we should give the public, maybe do the 1 or 2 minute public comment on those items, but when it comes to the strategic planning workshop part of setting our priorities, that should be like pop up, raising hands, ideas, and us intaking what the public suggests.
I actually think that's a really good idea, is to do the time limits in response to Chair Rabbit and Sheriff Ingram. So that we don't engage on, because I'm actually concerned that we have 4 hours and we have 2 public people who are going to like to share a lot of information with us. And so I'm concerned that that time is that our planning time could get eaten up a lot anyway. Be that as it may. So we'll just.
Yeah, so what do you guys think about that? And we'll open this up to public comment after. Finish.
I think that sounds reasonable. I just think as a member of the Community Engagement Committee, I just feel like it's really important that the community feels like they have the time to give us the input that they've come to give us.
Yeah.
So that's where this comes from, my concern.
Okay. Any other thoughts? John, what do you think?
Everything I've heard sounds good to me. I don't think I have any other comments to add, but if you have questions for me, I'd be happy to answer them.
I do want to note that this is going to be in person only, that we're not doing a hybrid meeting, so. And I'd like to figure out a way for us to publicize this fairly widely, you know, and because I think it's an important, you know, I think it's probably the most important meeting that we have every year. So I know that Susan has her list and she will do a great job of getting it out to her people, but if we all have lists or organization, we ought to, I'm asking everyone to put it out on their personal list and.
And we engage with the county's public information officer or, you know, somebody that publicizes for the county? Or do we feel that that would be helpful?
I think that would be a great idea, you know, they send out that weekly, for some reason I now get it through the Register of Voters. Would you get that summary on Friday afternoon of the press releases for the week? I usually get 3 or 4 press release, you know, it comes in one email, and I don't know why it comes from the Registrar of Voters, it used to come from the county, but at any rate, I think maybe we should be putting out a press release that we're gonna hold this. And ask them to. Good idea.
Yeah.
Is that something we can look into, John?
Yeah, we could absolutely do that. They do press releases, you know, with us periodically, and this could be one of them, sure.
Regarding the priorities, I don't know if anyone, like when you asked that we have this discussion, Casey, did you have anything in mind on how we might list things or any ideas?
No, Lorena, I'm actually quite happy with this wide open. We're gonna discuss priorities, we're gonna hear from the public, we're gonna bring what we've been thinking about. That all fits under that rubric in my mind, so. You know, I think we can save it for that time and speak broadly and think broadly, that's good.
Okay. Awesome.
So I'm just looking to see whether the newsletter that we sent out today does not include the retreat. Can we get another newsletter out?
Yeah.
Like. In good time, that would be great.
I did see something that said,
I saw it on there.
yeah,
Oh, it's down here, I'm sorry, it is, it's below the follow us, okay.
that's why I said this is our second retreat, because I did see that said first
Right.
retreat. Okay, we'll open this
But that
item
doesn't
up
have
for
Links to anything.
public comment. So if you have any comments related to this item, you have 3 minutes and we'll go ahead and time you when you're ready.
Yeah.
But
It seems to me that it might be not a bad idea to have a line item here that's what is left over from 2023 that still needs to be done, and then make a timeline at that meeting for those conclusions. And I'm frustrated because in the old days, which some of us have talked about in the past, we've had a much more free kind of dialogue with the CAC members. And it's very hard to sit here and be very prescribed. You must I have so many things come up that are written down on my notes, but I can't do them because I was supposed to do them then in my 3 minutes. And it's really frustrating, and you want people to come to these meetings and engage, but it's really boring and we're not allowed to engage, and we have to have these very strict rules. And it was much more interesting in the old days when we could engage in a different way and ask questions and get answers and say, yeah, what does this mean? And so I would like that to be an item at the retreat, that we talk about the structure of having the public engage with the CAC meetings. And before I stop, I just want to name David Landward, because that was earlier in the presentation that I didn't get to talk about, but it was about police, deputies standing by when something happened, and I'm just dropping it into the room because that's one of the reasons I'm here. He was killed by the carotid artery chokehold.
Thank you. Any other public comments? Okay, we'll go with you and then you'll be next.
Michael Hilbert, I want to comment on what you said about the agenda. I think it's very important that members of the public be given an opportunity to express a comment or question to you, David Rabbit, or anything, because they're going to be on the agenda. And not preventing them speaking or whatever. Afterwards, the public should either be able to pose a question and make a comment on what went down, because, at least as far as the agenda goes, it's not even clear exactly what they're going to be saying, until you're there, you hear them speak it. And so after they, do whatever, then, open it up for the public to say or question. So that's all I'm saying, just take the public opportunity. Just while I was gonna comment about speakers that you may have, I hear and go to David Rabbit's speaking various times over many years, and most people, I think including him, prefer to have something where they have time. And 5 minutes is a long time. 15 minutes is a huge amount of time for someone to actually speak without actually responding to questions. So you may want to provide them a guide as to how much time you think, and then how much time will be for questions. So for instance, 10 minutes for speaking, you kind of have to prepare kind of an agenda for themselves to speak for them. That's a long time. And then, 20 minutes, that's a long time too. So, whatever you think is appropriate, but expressing that, there's really in the world to do that. To give them. And then, for instance, if you did that, 10 minutes to 20 minutes, you got both done an hour, you got 3 hours left. It's probably a wise idea to give them a parameter. Otherwise, they could come and have a really big thing that they want to convey with, and without much definition to it. So it may be wide ranging and have a lot, that doesn't really apply, maybe, who knows. But having more specificity, most speakers really appreciate that.
Thank you.
This is wrong. 10 minutes is not a long time for a politician.
Oh, that's what I mean, but if they have something to say.
Yeah.
It's short. But
Yeah,
it's
right,
cool,
right.
That's the.
I want to just chime in what Alchina was saying about what we were used to in the past. I think that might be part of the reason why the public is not here as much, is because they don't feel that their opinions are cared about as much, because Jim Duffy, who was, at the time, was on the CAC, might disagree a little bit because he thought we took up too much time. But it took longer to get business done. But people actually felt very engaged. I like the fact that last year, I did feel that most people felt that they had the opportunity to speak and be involved. And so if that's going to be the same, I'm sure that would be appreciated. Just one minor point, it's 10 to 2. Last year it was lunch in between. I'm assuming it's good for the public to know if there's going to be lunch in between. I assume there is, but it might be nice to put that in.
Okay. Thank you.
You did, it provided lunch.
Yeah, we got some trays at Costco. Oh, yeah, and I brought
I thought you ate lunch while you did this.
yeah, like we could.
We did working
Like a
lunch.
working lunch.
Yeah, right. And we'll put in breaks and stuff. Okay. You already went, sorry. We'll go through. We'll wait after everybody else who hasn't gone.
So I'm a little confused, please clarify, this is number 11 on the agenda, this is an open time, or is this, are we commenting just on the retreat right now?
Right now, we are commenting on item 9A
Retreat.
for the retreat. Did you have comments
So,
for that?
yeah, so I don't know if this perceives a potential topic or something about an overview of the whole review and enforcement process and options, so, kind of like what she was talking about, a framework or an overall perspective or context of how this whole process works. In particular, what happens, I mean, we're relying on the police to say they're in the wrongdoing before we get disclosure. Whatever we're supposed to do, the police say, like this gentleman said, oh, there's nothing to disclose, nothing to see here, move along. Now, where do we go from there? Like, an overview of the whole context of what we're trying to accomplish here and different avenues, maybe something that could be valuable, specific, that, what we're doing, what you guys are trying to do, review law enforcement, what are we supposed to do when, you're talking about 37, oh, we're all putting it on this police to say, okay, we did bad, so now we're supposed to disclose this. What about when they say we didn't do bad, so we're not gonna disclose this, when they really did do that? What are we supposed to do? That's the whole point of being here, we're supposed to be reviewing them. Not depending on them to review themselves, that's absurd in my mind.
Okay, thank you for your comment. We have Barbara with the hand raised on Zoom.
First of all, I want to agree with Susan that a politician, 15 minutes is very short for them. Totally. And then on communication, I think for the next coming year, I hope you guys make an action item to up your game on communicating with the public about things. It doesn't feel like there's a great strategy around it. Sometimes items are buried in a newsletter. And I'd like to see also, especially for this retreat, for you to ask your Board of Supervisors person that appointed you to send that information to their list, because they have very large lists. Because I think it'll make the public see that the Board of Supervisors thinks this is really important. So I think that might help in terms of outreach and maybe reach some eyeballs that your newsletter or the webpage doesn't. So my 2 cents. Thanks.
Seeing no other hands raised, we'll bring it back to you, but we'll give you only 1 minute to finish your comments.
It's okay, I just think, as I recall, I think you were saying you had a previous retreat like last year. Well, maybe you're considering a different CAC or something, but there were other retreats, I believe, in the previous incarnations. But they have some retreats.
Okay, thank you for your comment. So we'll go ahead and close public comment and then bring it back to the CAC for discussion last closing comments. But I did want to say that we did not say we won't have public comment for Supervisor Rabbit's or Sheriff Ingram's presentation. We stated that we would use when we go over those 2 items, we will follow the standard process of timing individuals for their comments. And then have like a certain time period where we take in comments and then close that out and move on. And we will do the same with Sheriff Ingram's presentation for the setting our priorities. That's where we want to have it more interactive. We won't be using the timer. We'll take hands raised and things like that. So we will be taking public comment on the items on the agenda. And then I think we do typically tell the sheriff and the chair of the board that they have like a certain number of time to provide their presentation, right, John? So like if we told them.
I'm sorry, I didn't.
What did we do last year?
I didn't quite follow the question.
So when we had the sheriff and Supervisor Corsi come and speak to us, didn't we tell them that they only had like a certain amount of time to speak and then we'd have questions and then we would move on?
We did, and in both cases, we had some conversation with them in advance about that because, you know, they're people who are fairly busy too. So on the one hand, we want to give them as much time as they'd like and want the CAC to have opportunity to talk to them. On the other hand, they do have other commitments even on a Saturday, so we don't want to overcommit their time either. So if there's some particular amount of time the CAC would like, you know, with either one of them, that would be a useful place to start the conversation.
Okay.
I say we give them 20 minutes at least for their
So that's
remarks,
and include public comment?
and then add public comment to the comments. Maybe 15 minutes of public
And
comment.
I would say
And, you
10
know,
and
you
we
wouldn't-
go over anyway.
You wouldn't necessarily have to have public comment after each speaker either, depending on how you want to structure public comment. You could have a public comment session after each speaker. You could have a public comment session after both speakers. You could have one comment section before, and then that would give those two speakers something to sort of reflect on or respond to. You
Yeah,
could just have public comment at the beginning, at the end of the meeting, and or in the middle of the meeting. You have a great deal of flexibility about how you want to structure that.
yeah. I think, after they let us know, like I remember last year, I think Sheriff Ingram had to go to another meeting, so, or Supervisor, of course, they can't remember, but if they have other commitments and we need to squeeze in public comment in between, we'll do that, or I guess we'll figure it out. Once we have more details.
So can I ask, does anybody have from the CIC have a thought about how much time they would like to give? Supervisor Rabbit and Sheriff Ingram, it's our workshop, it's our non-retreat.
Yeah.
It's our, you know, it's ours, so we should decide how much time we want to give them. So we don't, you know, we don't have to be passive about that. I think we should decide.
I like the idea of actually having the public be able to, I don't know if this is appropriate, but like ask a question that they, I mean, you know, that they might work into their comments to it, you know, so that if the public comment could come, I mean, if somebody had a question for the supervisor or for the sheriff, that they could share that. And then hopefully the two presenters would work that into their presentation, and then there would be some public comment after that. I don't know, but it just seems to me that if we want the public to feel like, you know, we're responding to them and our representatives are responding to them, then they need to have an opportunity to say what their question might be ahead of time. I mean, instead of just following up their comments.
So I feel like there's two kinds of questions being addressed here. One is, what are we gonna ask for from the speakers?
Yeah.
And the other one is, how are we gonna handle public comment?
Yes.
So focusing on what are we gonna ask for from the speakers? We have a supervisor and we have the sheriff. Our entire purpose here is to deal with the sheriff's office and the sheriff's department. That seems like more time is required and the request is larger, right? Whereas the supervisor has this world of concerns, interests, and work that the board does, but this is neither the time nor the place, right? The meeting that we're gonna have on the 24th is neither the time nor the place for a presentation about what the Board of Supervisors is doing, is it? It's about what's relevant to us in the work that we have in front of us, right? So it seems like a more limited period of time to ask the supervisor to speak to the issues, the interests, etc., that he has and that the board has with regard to this group. And then more time for the sheriff to talk to us about law enforcement's concerns, and our work with regard to Idolero and law enforcement, right? So I would think we'd want twice as much time at a minimum from the sheriff than we would want from the supervisor, and I would think they'd be comfortable with that.
I agree with David's comment, but I wanted to add that maybe you could do a hybrid with public comment at the beginning. So that the public can get their questions out and the two elected officials can maybe work that into the response. And then after the two elected officials give their presentation, open it up again. I don't know. Cause I think one or the other probably doesn't work, or I think we just have to have the public feel like they got their questions out there. I don't know.
I think the only concern that I have is assuming that both Supervisor Rabbit and Sheriff Ingram are going to arrive and be there at the same time. Because if I remember correctly, last year, Sheriff Ingram arrived later. You know, I don't know whether Supervisor Corsi was done with his comment or not, but they weren't both sitting there. So just in thinking about how we handle the public comments, that's something to keep in mind, is that we can't do them both. That doesn't mean that we can't do public comment for each of, you know, which could be questions rather than comments.
Well, if we ask them both to be there between 10 and 11 or whatever the identifiable period is for them and their presentations and their input and so on, hopefully you can get a commitment for like between these goalposts, right? We hope to be here.
I was going to propose, I feel like we did this when I worked on the debate, I can't even remember what we called it, but I created a form that was sent out to the public so they could send us questions that we could take into consideration for asking the candidates. So what if I did something similar, and then in the press release that is gonna get sent out, we send a link to the public to submit their questions using that Google form, and then have a deadline set for the community to submit their questions, and then we can send those questions to the sheriff and Supervisor Rabbit so that they have an idea of some of the things that the community is concerned about that they want kind of addressed, and then that way they're kind of prepared for some of the questions, and we'll still have the opportunity for new questions during the meeting.
So long as the public does not get the idea that any and all questions that are submitted
Yeah, we'll put
are
like a
going
little
to be addressed,
disclaimer.
because these poor people can't address, 200 questions.
So,
Yeah.
I don't know, we have 14, we have, essentially 14, 15, 16 days. I don't know that we're gonna be able to get all of that done through a press release. Have a press release go through the PIO. Get it out, get the Google forms back, get them.
Well, I could do the Google form and like, when I get.
No, but I mean, and then collate them and then get them to that. I mean, we just need to think about that time, and maybe we can do it, but we need to schedule that. We need to know, we need to have a press release out by such and such a date. We need to have the form back by such and such a date, and we need to have the information. I mean, if I were speaking on a Saturday, I'd at least want 3 or 4 days ahead of time I mean, I might not write it until the morning of, or I might not write it until the night before. But I would be thinking about it. And so I would want those questions 3 or 4 days before.
But not only that, I think with the sheriff even writing his open letter to the PD, like, I don't see his comments straying very far from what he's already said about his first year in office. So even if we did all that work, which I appreciate you offering to do, I agree with you, it's a very short timetable. If you did all that work in the next 16 days, I would be very shocked if he entertained any of those questions, knowing that he's already written this open letter and you know, they asked their adaptation, like all of his talking points, he already has it, right? So we have as CAC members have a little bit more leeway to push him on some items, but you know, I want to be respectful of what Barbara said, like if we need to make sure that we're getting the voice out, hearing the voice from the community, I'm wondering if that is something that we redouble our efforts for like the entire year, right? Not something we're trying to get through for our strategic plan, in my hometown in Windsor. So, with that said, I'm certainly gonna think of some things that are in context to what we already put to him. But given that that would be quite a bit of work to try and pull off in the next, 16 days, I'm not sure if it would be worth the time. But better yet, put that work into where we think we can actually get a response in the next several months. So it's just an idea.
I agree and disagree. I feel like we should do it because it's our job to ask the community like what their concerns are. I feel like at that point, we would have a record of questions that they're concerned about. We would share that record with the sheriff and with Supervisor Rabbit. CAC members would have that list of questions, and then we'd provide the questions, like let's say we set the deadline as, I don't know, the 20th. So we send the questions to the sheriff and the supervisor and then let them know, these are some of the things that were brought up. Please consider addressing some of them. And if they don't, well, we let them know ahead of time, but then we would have those questions and have the opportunity to bring them up after they give their little talk. And also, it would help us in like knowing what interest the community has when we get to the section of the priorities.
Yeah.
And I was going to ask you, John, I can create a form when I get home, and then I feel like we just need to send the form with the disclaimer that, the community knows those questions are not all going to be addressed, but it gives the speakers an idea of things that the community is concerned about that we would like them to bring up when their time is, when they're going over things on the agenda. And you just send out that link to that form and we'll collect it. And, I know it's a public record. I think I made a email address specifically for Iolero so I can make forms. And then you guys would send the information of the location and all of that. I feel like we're not doing anything new except adding a link to a form that I'm gonna create. And so how long would it take for you guys to have that in like a newsletter or in an announcement for all of us to share so that the community has it? Like what
I
would be
guess
the-
I'm not clear on the question. So are you asking how soon we could get a newsletter that included the Google link?
Yeah, and the information.
We use a contractor for that, Ricardo at Watson Lab, so I'd have to ask him, but usually it's something we can do next day or thereabouts, but I haven't specifically asked him that question, so I don't know.
I mean, Lorraine.
But I would say though, I think even if we did that, I agree with some of the other speakers like Darnell that is a fair bit of work to get that out to the public, have people submit questions, get them back, collate them, get them to the supervisor and the sheriff in a way that's useful to them to actually formulate some comments. I mean, we can give it a shot. I have a low confidence that will end up substantially changing the conversation that we have with either of these two at the retreat. But if you want to try it, I'm happy to give it a shot. I don't want to raise expectations that I think it's going to fundamentally change what we're going to hear from either one of these two folks who already have plenty of things they'd like to tell us of their own, right? I mean, not in a negative way, but like they don't get to talk to us very often. And, it's been a whole year since we've had the sheriff. There's, I'm sure lots he would like to bring up with us too, right? So And we're giving each of these people a relatively short period of time. You know, we were talking earlier about maybe 20 minutes. But we could certainly give it a shot. I just, you know, I don't want to raise expectations that all those questions are going to be answered.
Can I
I'm
make
a little
another-
worried about making people feel like let down by like their questions not being answered, right? But maybe I'm overthinking it.
I'd like to offer another suggestion. I think soliciting questions, not necessarily for the sheriff and David Rabbit, but soliciting ideas from the public through a Google form is a great idea, but let's just not tie it to our strategic, to our retreat, so that we can actually have time to formulate the questions that we want to ask. Find out, you know, figure out what information we'd really like to elicit. And figure out a really good way to get that out. You know, really, and just do it. This is the kind of stuff we were talking about with the community engagement committee right before this meeting. And I just think that we could do this in a really, you know, I just think it's a great idea that we could do in a really great way if we didn't feel this pressure to push it out.
And it's not just to the.
Yeah.
It's to us.
Yeah.
Yeah, I if you don't mind me chiming in, I like that a lot. And like Lorena, I like your the Google form that we got out to the public and asked them their input. I think they might find it more satisfactory if those were, like Nancy was saying, suggestions for the CAC about things to talk about at the retreat and topics to cover for the upcoming year. And if we get it all back in a timely way, we could absolutely share it with the sheriff and with Chair Rabbit, and they'd have a chance to at least think about it. But then, you know, the expectation we're raising with the public is more the CAC wants your input for conversation at the retreat, as opposed to promising that someone else that's not one of us is going to answer the question, right? Which I think is maybe putting too much pressure on our speakers and too much pressure on us.
I think the one part that I think I said that you missed was not tie it to the retreat, so we would have more time to do a better job. Because I don't think 16 days is enough to do a really good job of getting it out and getting the questions formulated in a way that will give us the answers that we would like to hear.
Are you thinking then that you're more interested in maybe one of the exercises at the retreat being coming up with the questions that we then ask the public? And
That might be an exercise at the retreat. That's not a bad idea.
It's a component of a much bigger strategy.
Exactly.
So let's discuss the strategy at our strategy meeting. And then, and let that be like the first task within it, right? Because I don't think we all have to come up with the goals for any new ad hocs on the 24th. I'm hoping not, right? Because I want to finish mine. So let's double down on that strategy of engaging with our constituents to make sure that we are voicing their concerns and pressing the sheriff's feet to the fire where necessary. Right? And because again, I think with 20 minutes or a half an hour or in a 2 hour, like if I were him, or Corsi or Rap, I would come in with my prepared remarks and probably wouldn't stray too far from it. So I think that if we, to really get some juice out of this thing, let's continue the discussion and make it a part of the overall building up of to make sure that we're doing the people's work this coming year.
So no questionnaire, and we'll discuss that at the retreat.
Yeah.
It's part of the bigger strategy.
Yeah, and I think it could be our lead off hitter, like, let's talk about the questionnaire. Like, let's put it together, but someone, you know, we were first talking about questions and then we were talking about topics. I mean, those are both great, but I think it deserves us tabling this conversation to the retreat so we can dive into it. Because it has the potential to really harness some good information for us throughout of 2024's month.
And engaging the community.
Absolutely.
Yeah, I think community engagement strategy is definitely like something we should have a long discussion.
Community engagement committee? Yeah, he's an honorary.
I'm all about the rip. Okay, we ripping up on Ripple. And we're gonna bring it to a close. But yes. I mean,
So far, we have the list of leftover items for 2023. Trevor?
Oh, yeah, I just
Sorry,
wanted to
Trevor.
say, yeah, whatever the final outcome on what we decide to do before the meeting, I just wanted to say that I do support your idea. I was actually thinking the exact same thing before you articulated it. I think especially as it was mentioned, you know, I think it's a huge part of our role to be a bridge between the community and law enforcement and board of supervisors. And I think particularly because this is not a hybrid meeting, and there are people out in the community who A, might not know about it now, that's another press release, and B, would love to have some form of input, but won't be able to attend. So I don't think we should put too much pressure on whether or not, you know, it'll actually get weaved into the presentation of the sheriff or the supervisor. I think just the intrinsic value in the community feeling seen and like, hey, we're pushing this event, we want to hear your feedback. And that's no reason to say we can't continue to do those Google Forms and continue to do that outreach, but I mean, however much the labor is, if you're willing to do it, or if I can help on it, I think it would be worthwhile, because I think the community, there's a ton of value just in them being reached out to.
right.
So can I ask a question? Could we send out a press release and say, you know, we want your comments, we want to hear from you, here's our email address? You know, you
Yes,
can't-
we did that last year as well, and we did not get
And
very
we're-
much feedback, but we got a lot of people that showed up in person at the meeting.
I mean, would that be something that would be sort of an interim thing where we don't have to create a Google document, we don't have to collate, you know, we just have that information? I mean, unless people think that that is too, either too free form or.
I don't think we're asking for feedback. I think we're asking for input.
Well,
I mean,
I'm not saying,
No,
I don't
I
mean.
think it's different, you know,
Yeah.
I mean,
Did I use the word feedback?
Yeah. well, yeah, but anyway, and so I feel like if it did go out in the press release and it went out in the newsletter and it gave an email address, that's simpler than, you know, people having to get back to Google form and stuff like that. But I don't know if we, I mean, I think it could be stated in a certain way that they know what we're looking for. But that's what I think.
Okay, so,
I just want to throw out a real quick comment for me.
okay, we did close public comment, but we'll give you 1 quick minute to just.
Yeah, just a few seconds, actually.
And we
This
won't be
concept
reopening public comment.
For the
Sorry.
strategic meeting for you guys to consider, but I may not be here. I think this is a little bit of tangential, but it should tie in somehow, some kind of ranked choice voting. When you, because you're, I believe you're going to solicit a large number of concerns from the community. And it needs to be narrowed down as to what the priorities are, instead of letting the officials decide they want to talk about what they want to talk about, or whoever decides. In some kind of community ranked choice.
Yeah,
voting.
we do have a process in mind for that already. And we have considered establishing a process where we also identify the votes between, like, we want to let community members also participate this time, and being able to identify who is a community member and who is a CAC member who voted on the importance of a topic. So I think, and we will not, again, open public comment. It's already 8:12, so, do we have enough direction to create an agenda? Okay, I think everyone's comments and feedback will help Nancy and I and John and Lizette create an agenda that will be sent out. And we will do a press release, and hopefully Ricardo can get that out soon with the information and the email address where people can submit their comments and ideas for us to consider.
It would be really great if what we could get would be something that we could send, you know, something that looks like the newsletter that we could send out, and then we could send to our district. You know, like that, I could send to Lupe and say, hey, can you send this out to your people, but that looks attractive, it's not just an agenda. But that actually look, you know, and then
Like a
kind of looks
flyer.
like a.
I
like a
can
flyer.
forward our newsletter to Lupe and all the districts. Is that?
Okay, but
I think we were talking about us doing it as their representatives and saying, you know, that we would like them to do that as our, you know. Okay, so if, you know, if it could be just a newsletter with all of the information, but looking really cool, that they could then send out to their list would be great. Okay?
Something more formal.
Something that, the last time we sent something out, it was just the agenda. I don't want to send them the agenda. I want to send them something that looks more like what the newsletter, like the announcement of tonight's meeting looks like.
I can go over that. Maybe you and I can work on it.
Yeah.
And then share that with John and Lizette. Okay, any last minute comments? Okay, so we'll close this item and move on to the item 10, which is the reports. So we didn't intend on going over all of the written reports at this meeting. We wanted to get an idea of what everybody was working on and have that in writing, so then we can see what the work is, and then that way we can have a discussion on how to incorporate that into our strategic planning workshop. And we now decided that we will have an item on 20, you know, things that we didn't finish working on in 2023. I wrote that in. And so we have everyone's update. So if you really want to go over your report, you can do so. Otherwise, we have the written reports and we'll just quickly just say we don't have any reports to provide. But I'll go through the list. So we'll start with community engagement.
Yeah, well, we didn't do a written report because we weren't not that up for a
So then you should give us a report.
Anyway, so we had a meeting tonight and everything that we've been talking about is so great. Right? We talked about wanting to have a plan of action for 2024 for community engagement. We wanted to talk about it being a responsibility of everyone, about using our substantive topics to do webinars so that we could share the information that we're learning about the various topics that we've undertaken.
Engage with other community groups.
And to encourage new membership on the community. engagement. So that's it. The rest I'll leave for the retreat.
Okay, thank you for racial and identity profiling that. You know, aside from what we provided, we don't have an additional report to provide. I will say, just quickly going back to the previous item, that when we go over leftover things from 2023, we're gonna take these reports that you all submitted and go over like ideas and stuff. Like I know Casey wants feedback on some things, or, you know, kind of you'll present your report and then the CAC and the community can provide feedback on how you can move forward with your ad hoc, because it sounds like we all kind of want to continue our work. We haven't really accomplished it, you know, anything. So, and we have timeframes for when we want to accomplish things. So the workshop is going to help us, you know, get there with additional feedback. I feel like we never have enough time to do that here. So, yeah, I just wanted to add that. Sorry, I'm going back and forth. Next, recruitment and hiring practices.
But we have a list of questions that we sent Sean, and Sean is trying to work with the personnel manager. Is that right, Sean? To get to.
Yeah, thank you. Yeah, I'm at the mercy of the personnel manager on that one.
So you and I can talk offline about suggesting some dates and how to move that a little along, okay?
Yeah, certainly.
Thank you.
Policy recommendations review.
Yeah, I'm not gonna try to add anything. You got our written report. Our committee seems to have dwindled to me. So I'm gonna be.
You couldn't borrow.
I'm gonna be looking for intelligent and committed input into our work when we meet for our strategic planning.
Okay.
Okay, thank you. Evictions.
So we have a report in here, but we did meet on the 22nd of January. We are meeting again in a couple of weeks. And other than what's in the report, we have nothing further to
Okay,
report.
thank you. Now we'll move to open time for public comment, this for any general items, under the subject matter jurisdiction of the CAC, and due to time, we will limit it to 2 minutes, so if anyone has anything to bring up for open time. Yeah. Okay, 2 minutes, we'll start with you and then we'll go.
The one thing I was gonna say is I was 100% in agreement with you as far as getting two parts of information, something before, and maybe you can have just some people write something when they get here, or when they get wherever the retreat is, to write down the comment, and then you guys can review and offer those to the speaker if they amend their pretty much word, and then have it open questions after. But what I was hoping to say here is I understand somebody was sprayed with bear spray, essentially pepper spray, right in their face inside of a location. I don't necessarily want to disclose it at this moment. It was a woman who was sprayed by the manager of the facility, who entered the room with his own master key without identifying or stating in advance that he was doing that in private residence, if you will. I say that residence word with a bit of comment, but my point is that we found the person there. He sprayed him in the face with pepper spray, and the sheriffs came and arrested him and charged him with misdemeanor something or other, as opposed to a person in possession of pepper spray, and using pepper spray on someone without any threat whatsoever. And so that seemed pretty odd. And there are people who are interested in having a complaint filed, and I wanted to find out exactly what the procedure would be for that. That was my question.
Okay. Thank you. Any other comments, Robin? Go ahead.
Yeah, I want to relate to you that, before I was even formed, I did a formal written complaint about the conduct of the deputy who came out to my house because basically intimidated me into confessing to something I had nothing whatsoever to do with. You know, to put it simply, like there was a drug user next door to me who was shooting things with a pellet gun. And the people across the street apparently had their house shot at in the middle of the night, and the neighbor kind of assumed it was me. So the deputy gets set out to try to intimidate me into confessing because he assumes the neighbor must be right. So anyway, I get a letter in response to my complaint was the deputy did nothing wrong. And kind of accidentally, I discovered that there was a report written by another deputy who was out there previously, which had my name on it. And it was purely by accident that I even knew that this other deputy wrote the report, because it's not even the same deputy that I made claims on. So anyway, this report, I got a copy of it, and it says, do not duplicate. Now, I'm not allowed to put it on Xerox machine apparently, and I don't necessarily agree with that because I think it's a public record and I requested it. So I would like to say that I would like to make a copy of that and forward it to the CAC or to Alvaro. You know, I'd like to ask, Dawn, if this document is the report is strictly about me with my name on it, says do not duplicate. Can I make a copy of it and give it to Dawn? I think I have that right. I don't, I'd like to get an answer to that question because, I don't believe that that's fair to me to try to accuse me of violating the law to duplicate the report for consideration.
Okay. Thank you. That's time. Thank you for your comment. We don't have any hand raised on Zoom and no additional public comment here. John or Lizette, if you could just remind us, what's the email address that members of the public can use to submit complaints against the sheriff, who I am aware of? Is it
Well,
still, yeah,
even better than the email address, I would say go to our website because there's a complaint portal there. And it asks some key questions that help us do a better job on the complaint. than if someone were just to send an email. You know, like asking for some of the key information that is useful to us and actually investigating the case, or that's useful to the sheriff's office and investigating the case, depending on the kind.
Can that be anonymous?
Yes, it can be anonymous. Mhm.
Thank you,
It
John. And
is,
then,
you know, harder for us to then get back to the person or to investigate it if it's anonymous, but you can do it anonymously, so.
okay, thank you. And then for the other comment, I would just say you can email John directly and see if he has any suggestions in your case. We'll move on to requests for future agenda items. Are there any requests for future agenda items?
This would be for, not for the retreat, for the next, March, April, May, or month of regular monthly meetings.
I would just be interested in knowing how we get new CAC members. Can we talk about something, can that just be information?
Maybe just,
Because it feels
We can
like,
put that under the vacancies.
okay. Okay, and seeing no other comments, we'll CAC
And
announcements.
assume you all are done.
Any announcements? Seeing none? Item 14, adjournment. Thank you all for coming to this meeting. We're going to adjourn at 8:25 p.m. and our next regular meeting is on March 6th in this room. Remember that our strategic planning workshop is in Windsor, Darnell. Thank you all for being here.
I don't have library.
Good night. Thank you, John. Thank you, John. Nice to see you.
All right, see you in a couple
Bye.
weeks.
See ya,
Bye,
John.
Sean. Thank you, Sean.
Thanks, Sean.
Good night, John. How are you doing?
Good, you?
Oh, my God.